In this section, we will look at how the government has conceded that the Investigatory Powers Act, IPA, does not provide adequate protection for confidential journalistic materials and sources from surveillance. The IPA is a UK law that gives wide-ranging powers to the police and intelligence agencies to collect and access communications data, such as phone calls, text messages, and internet history, of anyone in the UK, regardless of whether they are suspected of any wrongdoing. The IPA also allows the state to intercept and examine the contents of communications under certain warrants. However, these powers pose a serious threat to the privacy and freedom of expression of journalists and their sources, who rely on confidential communications to expose stories of public interest and hold the powerful to account. Journalists may have their communications data collected and stored by the state without their knowledge or consent, which could reveal their contacts, sources, movements, and activities. Journalists may also have their communications intercepted and examined by the state, which could expose their confidential materials, such as leaked documents or whistleblowers' testimonies. The government has admitted that the IPA does not comply with the European Convention on Human Rights, ECHR, which guarantees the right to privacy and freedom of expression, in relation to the protection of journalistic materials and sources. This admission came after a legal challenge by Liberty, a human rights campaign group, and the National Union of Journalists, NUJ, which represents thousands of journalists in the UK. They argued that the IPA does not require sufficient safeguards to prevent the state from accessing confidential journalistic information without prior independent authorization or oversight. The legal challenge was based on a landmark ruling by the European Court of Human Rights, ECHR, in 2020, in the case of Big Brother Watch and others v. the UK. The court found that the UK's previous mass surveillance regime, which was replaced by the IPA, violated the right to privacy and freedom of expression by failing to provide adequate safeguards for confidential journalistic materials and sources. The court also established that any interference with journalistic communications must be authorized by an independent body, such as a judge or a judicial commissioner, before it takes place. The government has agreed to amend the IPA to bring it in line with the ECHR ruling, but Liberty and NUJ claim that the proposed changes are not enough to protect journalists and their sources from unlawful spying. They argue that the IPA still allows the state to collect and access communications data of journalists without prior independent authorization or oversight. They also argue that the IPA still does not require prior independent approval for intercepting or examining journalistic communications in all circumstances where it is necessary, such as when using search terms that are connected to journalists or when conducting searches that are likely to lead to the discovery of confidential journalistic material. Liberty and NUJ are challenging the IPA in the Court of Appeal, seeking to ensure that journalists and their sources are protected from unjustified surveillance that could undermine democracy and the public's access to stories in the public interest. The Investigatory Powers Act, IPA, is a controversial law that gives the UK government sweeping powers to conduct mass surveillance and hacking without adequate safeguards for privacy and human rights. The law also fails to protect journalists and their sources from being spied on by the state. The IPA allows the government to obtain communications data, such as who journalists contact and when, without any prior judicial authorization or oversight. It also allows the government to hack into devices and networks, potentially compromising the security and confidentiality of journalists' work. The IPA does not require the government to notify journalists when their data is accessed or hacked, nor does it provide any meaningful remedy for journalists who are subjected to unlawful surveillance. The IPA poses a serious threat to press freedom and the public's right to know. It undermines the ability of journalists to protect their sources, who may be whistleblowers or other individuals exposing wrongdoing or matters of public interest. It also creates a chilling effect on sources, who may be deterred from contacting journalists for fear of being exposed or prosecuted. This in turn affects the quality and diversity of journalism in the UK, as well as the trust and confidence of the public in the media. The Court of Appeal is hearing a challenge by Liberty and the National Union of Journalists, NUJ, against the IPA's lack of protection for journalists and their sources. The challenge is based on the European Convention on Human Rights, which guarantees the right to freedom of expression and information, as well as the right to privacy and data protection. The challenge argues that the IPA violates these rights by allowing indiscriminate and disproportionate surveillance of journalists and their sources, without adequate safeguards or remedies. The challenge also relies on the case law of the European Court of Human Rights, which has recognized that journalists have a right to protect their sources under Article 10 of the Convention. The court has stated that source protection is essential for press freedom and democracy, as it enables journalists to report on matters of public interest and contribute to public debate. The court has also stressed that any interference with source protection must be justified by an overriding requirement in the public interest, and must be subject to prior judicial review. The challenge by Liberty and NUJ seeks to establish that the IPA does not meet these standards, and that it must be amended to provide adequate protection for journalists and their sources. The challenge also seeks to ensure that journalists are notified when their data is accessed or hacked by the state, and that they have access to an effective remedy if their rights are violated. The challenge aims to uphold the principle that journalists should not be forced to reveal their sources or confidential information in court, unless there is a compelling public interest that outweighs the harm to press freedom. The outcome of this challenge could have significant implications for journalism and democracy in the UK, as well as for other countries that may follow the UK's example in enacting similar laws. The challenge could also set a precedent for how human rights law can be used to protect journalists and their sources from mass surveillance and hacking in the digital age.